All right. Good evening, everyone. My name is Anthony Lewis, and I serve as the Director of Community Engagement and Education Division at the Michigan Department of Civil Rights. I will be your moderator for the evening. For full accessibility today, it is critical that speakers first identify themselves by name before proceeding to speak and mute their microphones after they are done speaking. We have ASL interpreters on screen, and live cart captioning is available by turning on subtitles using the CC icon on the lower part of the screen. We will have a question and answer portion during today's session, and attendees can use the Q&A function on the lower part of the screen to type in questions for our panelists at any time. With that said, it is with great pleasure that I welcome you to the third monthly installment of our 2023 MI for Michigan Response to Hate virtual campaign forums. We will have a new installment every month through September, at which time the campaign will culminate with our annual My Response to Hate conference. The spirit of the campaign was captured by our team through the development of the PSA, which is to follow. It is our hope that the campaign provides you with information pertaining hate and bias prevention that you can implement and use in your daily lives, at your places of work, in your schools, and in your communities. So without further ado, we are going to jump right into today's topic. So if you please shoot the PSA.
Did you know that race is the #1 motivating factor for hate crimes in the United States?
Did you know that hate crimes against Asian Americans have increased by over 73% since 2019?
Did you know that there are state and federal laws that protect you against hate crimes and bias incidents?
The Michigan Department of Civil Rights and the Michigan Alliance Against Hate Crimes have launched the My Response to Hate campaign to inform Michiganders of hate crimes and bias incidents occurring in Michigan.
You can take action in your own way by showing love, not hate.
If you see something, say something.
Support victims. Report the incident.
Make a commitment.
My response to hate.
My response to hate.
My response to hate.
My response to hate is love.
Visit michigan.gov/MDCR for more information on hate crimes, bias incidents, and available resources.
Thank you for that. Today, we'll be talking about creating schools that are safe and free from hate. We have a dynamic panel of presenters lined up for you today who will lead us in exploring the state and federal civil rights statutes applicable to schools, along with ways to operationalize these laws through policy and practice. Our first presenter will discuss schools' obligations to provide safe and hate-free environments for students according to the state's civil rights laws. Please welcome Attorney Marcelina Trevino, who is currently the Director of Enforcement and Legal at the Michigan Department of Civil Rights. Before that, Ms. Trevino was promoted to the Director Managing Attorney for the Office of Legal Affairs. She began her career at MDCR in 2011 as the Reconsideration Attorney, working on appeals for the department. Ms. Trevino holds a BASW from Michigan State University, go green, go white. In 2001, she obtained her MSW from the University of Michigan, Ann Arbor, go blue. In 2006, Ms. Trevino obtained her JD from Thomas M. Cooley Law School in Lansing, Michigan, and was admitted to practice law in the state of Michigan in May 2007. Ms. Trevino, you now have the platform.
This is Marcelina speaking. Thank you so much for that warm introduction, Tony. I appreciate that. Good evening. As Mr. Lewis announced, I'm Marcelina Trevino. I am the Director of Enforcement at the Michigan Department of Civil Rights. This evening, I will be going through a short PowerPoint presentation, going through our general overview of our state statutes in which our department, the Michigan Department of Civil Rights, has jurisdiction. Next slide, please. Great, just to go over a roadmap for this evening, I'm going to go over some general overviews of the MDCR statutes, the state statutes, both Elliott Larson Civil Rights Act and the Persons with Disabilities Civil Rights Act. I'm also then going to focus on Article 4 of both of those statutes, which covers protections in education. I'm also going to discuss causes that may arise and what we see as far as complaints that come into our office, and also some trends, some of the actual cases, scenarios that we are seeing. Following that, I'd like to go over some best practices and then allow for question and answer, which I think will be deferred until the end of the program. Next slide, please. So generally, for our state civil rights statutes, both Elliott Larson Civil Rights Act covers and has protections under the protected bases that you see on the slides, which include religion, race, color, national origin, sex, which also includes pregnancy and sexual harassment, age, height, weight, marital status, familial status, arrest record when we're talking about misdemeanor arrest, and then the Persons with Disabilities Civil Rights Act covers disability protections. Both of these statutes also cover retaliation, meaning when you have participated in some type of protected activity, you've filed a complaint under any of these protected bases, you are also protected from any retaliation due to those filings and complaints. Next slide, please. Our state statutes, both with Elliott Larson Civil Rights Act and the Persons with Disabilities Civil Rights Act, prohibit discrimination in the areas of employment, places of public accommodation, which are anywhere that we shop, do business, are out, entertainment, etc. Places of public service. Here we're talking about law enforcement, public boards that you may sit on or that represent you in your communities. Education, which we will be focusing on today, and housing. Next slide, please. So as we talk about Elliott Larson and the Persons with Disabilities Civil Rights Act, particularly when we're talking about Article 4, which covers education, we are looking to that section to show what educational institution includes in its definition. So we're not talking just about K through 12. We're also talking about other public and private schools, academies, colleges, and universities across the state. We're also looking to nurseries, childcare centers that have education components in them, any type of professional or technical and vocational schools, and also even charter schools. Next slide, please. So what do these state statutes protect? What are some of the prohibited actions? What you'll find is here, this prohibits discrimination based on religion, race, color, national origin, and sex in all phases of our educational systems. I do also want to note that just last week, the governor signed an amendment to the Elliott Larson Civil Rights Act, which also includes 2 additional bases, meaning that there are protections and complaints of unlawful discrimination as it pertains to sexual orientation, as well as gender identity or gender expression. Note that weight and height are not included as we talk about education protections. Also, when we talk about disability civil rights and protections, we are specifically talking about the Persons with Disabilities Civil Rights Act, which again prohibits discrimination based on disability in the full utilization of or the benefit of an institution's or the services that are provided and rendered by the institution. Next slide, please. So let's talk briefly about claims that arise in education. What does that mean? What are we looking at when we're talking about claims? Well, we're looking at the relationships between the parties. And when we talk about parties, and when I talk about parties, you'll hear me say claimant and respondent. So a claimant would be someone who has allegation and brings allegations of some type of unlawful discrimination against an educational institution, which we name a respondent. Here you could see the relationship is a student of an educational institution, and also evaluating any difference in how that student, and here claimant, has experienced the full and equal enjoyment of educational opportunities that are provided by the respondent or the educational institution in these instances. And we'll get more into what that means and what that can look like as we're talking about state complaints. So the question I have on this slide is, can you use other examples, other types of students that fall into the protected bases when we're analyzing and looking at claims of unlawful discrimination under education? So yes, we do look at other students' experiences as it pertains on what full and equal enjoyment of an educational opportunity looks like. Next slide, please. So some of the claims that we see that arise in education, some of the adverse actions in an education setting that we look at and investigate at the Michigan Department of Civil Rights are full educational opportunities when they are not provided, meaning that because of some protected bases that we went through in the previous slides, a student is not given the same and full educational opportunities based because of a protected basis, whether that be their race, their disability, their sex, etc. Some unequal educational opportunities. So maybe some students have an opportunity to participate in some type of educational advantage or program, and others are not due to their protected bases. Again, race, national origin, color, etc. We also see some claims that arise in education as it pertains to discipline. So are there students of a different race who are disciplined more harshly than those outside of that protected bases? Also, lower grades. Our teachers and staff giving lower grades due to protected bases based on the same or similar work. And we have to look carefully at some of these because some types of assignments in school and educational settings are subjective. And so really looking to see how best to give grades across the board in an equal and equitable way. And then less access to extracurricular activities. We see that there may be some clubs, school clubs that students are able to participate in. Are some clubs given more advantages, given more access to school resources, even school staff, the time that they may have in order to carry out their club duties or responsibilities, activities, etc. Next slide, please. So claims that arise also in education as we talk about sexual harassment and a hostile environment. When you see on the slide here, it says HE. HE stands for hostile environment. There are two types of hostile environments. One, sexual, so a claimant, a student is subjected to some type of comments or conduct that was sexual in nature versus the non-sexual hostile environment in which there may be comments and conduct, but it's regarding their status in a protected class. So here, maybe females feel that there is a hostile environment being created by other students or even other staff, or again, a hostile environment as it pertains to race. So Black students are feeling like there is a hostile environment that they are witnessing or experiencing because of their status in a protected class. So there are comments, there are conduct that does that. When we look at hostile environment, we're looking at unwelcome conduct that students don't want to be faced with. And also the conduct or that communication somehow affects a claimant, a student, from the full use and equal enjoyment of the educational opportunity. So here, how is that hostile environment, the comments, the conduct affecting a student's enjoyment of their educational experience? Next slide, please. Again, as we talk about hostile environment, an environment is considered hostile when the school, the educational setting has different, it's permeated with discrimination and discriminatory intimidation, ridicule, and insults that is sufficiently severe or pervasive. And I want to make it clear that it's severe or pervasive. It doesn't have to be both. So when we talk about severe, it's something that's very extreme, extreme comment or conduct. And when we're looking at pervasive, we're looking at actions and activities and conduct that carries on, right? It's not just in one instance. There are various instances that alter the conditions of an individual's ability to take advantage of their educational opportunities. You'll see on the slide in the diagram, it shows hostile environment in the middle. And what we look at when we are addressing complaints of discrimination in a hostile environment is the frequency of the comments or conduct, right? Was it an utterance? What type of utterance was it? Humiliation of a student or a group of students, the severity of the issues and actions that have taken place. Is there something that is physically intimidating? Is that conduct physically intimidating? And malicious, just malicious acts, comments, and conduct as well. And so again, it doesn't have to have all of those things, but these are the instances that we look at when we are investigating complaints of hostile environment. Next slide, please. So I want to put this more into what has actually happened, what we see, actual complaints and allegations that have come into the Michigan Department of Civil Rights that we've investigated. And we see some of the trends of unequal treatment. We see the hostile environment that I just spoke about and discipline. So here are some examples maybe of a group of students who were in a club and have a Black student union, let's call it. And they reported that they don't feel that their club has been given the same opportunities at after school as the other after school clubs. They allege that the other clubs have teachers and staff that help them navigate the systems into internal approval of some of their events and how to process to make sure that their activities reach the rest of the student body. But for them, they don't have that support. They don't have access to those resources. In addition, some of the students questioned whether they have even the same access and information as some of the other groups, knowing how to navigate and carry out their club duties. That is one example of unequal treatment. For a hostile environment, we've seen where several Caucasian students have called a person, a Black student, disparaging names. And this conduct is carried on in physical threats, actual physical assaults, and some bodily harm, where parents have contacted schools to address the issues and maybe feel that the school, after being notified, did not take the proper steps to remedy the situations so that it didn't continue. Another one is really a student, a female student who was subjected to a hostile environment by an educator. Here is where sometimes the laws intersect, where we have a female student with a disability who is under an IEP, which I'm sure we'll hear about a little later from my colleagues. But here is where the Michigan Department of Civil Rights doesn't have jurisdiction over an IEP. However, the department does have jurisdiction if staff or students create a hostile environment in which statements are made about the student's IEP and disability in front of others in the presence of students who may not have even been aware that the student had a disability or is under an IEP. And when when parents then address the issue or attempt to address the issue with schools, and the conduct and comments still do not stop. And lastly, I'll give you an example of an education complaint of a boy who was suspended. And this one we do see often. A boy was suspended for 1 day due to a physical altercation. However, the family is aware of a female student who was also in a physical altercation and was not suspended. Her discipline was different than the boys. Again, family making allegations, and for us to investigate why the male student was disciplined more harshly with suspension when a female student who was also engaged in some type of physical altercation was not suspended. Next slide, please. So what do we take from this and these examples? Looking at best practices, some of the things that are important are addressing the issues as they arise. So really working with schools, school staff to be transparent and own that there are incidents that are happening at their school. There is no shame in being transparent in that and addressing the issues as they arise rather than putting them off and seeing if they'll just go away. They don't go away. They actually become worse as students and staff may not see that there's anything wrong with the conduct and the issues that have risen. The other is follow up with issues and complaints. This is both for parents and for educators. Follow up, if something is happening with your students in the school, it is so important to notify the school leadership and staff that something is happening. In addition, schools, if something in an incident is happening with students, it is important to reach out to families and also see how these issues can be remedied and addressed appropriately and in a timely fashion so they don't escalate into something bigger and worse. Check in and provide support and resources. Again, for schools, check in with your staff, check in with your students, parents the same, check in and provide the support for your students and working together and collaboratively with the schools and educational institutions. And then ongoing education and training for staff. There are so many laws and protections and resources out there to train staff to prevent these types of situations, but also to address them immediately and appropriately. And then conduct ongoing policy reviews and equity assessments. Yes, it's great that school systems and districts have policies in place that are supposed to prevent and or address incidents of unlawful discrimination. However, it's so important to keep conducting, whether it's annually, every 6 months, to really go through those policies and procedures and reviews to make sure that they're promoting a healthy atmosphere for your staff and your students, and that they are equitable. There are equitable outcomes for students. Again, open communication and transparency is what really can address and make healthy educational environments for students and staff and communities all around. Next slide, please. So with that, I will defer for questions till the end of the program, and I'll pass it back to Tony Lewis. Thank you so much for your attention this evening.
Well, thank you. Thank you, Ms. Trevino, Marcelina, for that insightful look into how schools can protect their students and themselves. I'm sure that we'll have questions at the end of the program. Right now, we're going to continue exploring schools' obligations to provide safe learning environments that are free from hate, but this time from a federal perspective. Please welcome Chandra Baldwin, who is a senior attorney with the U.S. Department of Education Office for Civil Rights. She has been with the OCR since 2007 as an attorney With OCR, Chandra investigates civil rights complaints against elementary, secondary, and post-secondary institutions alleging disability, sex, race, national origin, or age discrimination. Chandra also provides technical assistance and training to students, parents, school districts, and post-secondary institutions. Prior to joining OCR, Chandra practiced with the law firm of Squire, Sanders, and Dempsey, now Squire, Patton, and Boggs, in Cleveland, Ohio for 6 years. Her primary focus was education law, litigation, and labor and employment law. She has provided counsel to public and private school districts, colleges and universities, municipalities, and other government entities. Chandra has also practiced in Chicago, Illinois, Cincinnati, Ohio, with a focus on education law, labor and employment law, and civil rights litigation. Chandra was admitted to practice law in the state of Ohio in 1993. Ms. Baldwin, we are so glad to have you with us today and eager to hear your presentation.
Thank you so much. Thank you so much for the warm welcome and the kind introduction. I'm so happy to be here today to talk about the laws that we enforce, especially related to harassment and discrimination. So if we can start the PowerPoint. And if we can just go ahead to the next slide, that would be helpful. So I want to speak a little bit about OCR, which is what we call ourselves. OCR is a sub-agency under the U.S. Department of Education. And if you could think of it as the U.S. Department of Education is a federal agency and is an umbrella, if you will, with several other sub-agencies within it, such as federal financial aid and other organizations. So our task is to investigate complaints of discrimination. We do this in an effort to ensure equal access to education and to promote educational excellence throughout the nation through our vigorous enforcement of civil rights. So as I said, the majority of our work is complaint driven. And what that means is that, and we use complainant and recipient as our name. Complainants typically are either students or the parents of students whose students are a minor. So this could include public school district students, and parents, or regardless of whether they're public or private, colleges, universities, and other post-secondary institutions. So a cosmetology program, a certificate program, licensure program, such as related to nursing or other allied health fields. Again, about 90% of our work is complaint driven, and complaints with OCR can be filed online at our website, which we'll have again at the end, but it's www.ed.gov. And then within the Department of Education's website, you just search for OCR complaint. We also conduct compliance reviews, which is actually our office looking at data to see if we find perhaps evidence that there may be a problem at a school district, and then we open up our own complaint to check into whether there is or isn't a problem. We have a significant amount of policy guidance on our website. We do rulemaking, we provide technical assistance, which is what I'm doing here tonight. And the U.S. Department of Education's Office for Civil Rights has a fairly robust civil rights data collection, which is available to any member of the public. If you look for civil rights data collection through OCR, you will find information about individual school districts. The information is about 2 years old, but we still find it generally very reliable, and it will provide information about the extent to which a school district perhaps disproportionately disciplines students of color versus white students, the availability of higher access learning opportunities for students of color, as well as other information that can be really useful to parents educators, or even students. Next slide, please. So today we're going to cover 3 forms of prohibited discrimination, specifically related to harassment. You're going to see some overlay between the information I'm providing you and the information from my colleague previously related to state laws. And that's a good thing. We like to make sure that there's a lot of options available, and we like to make sure that we're all generally using the same ideas and terms, whether it's federal or at the state level or even at the local level within your city or municipalities. For today's presentation, I'm going to focus primarily on race. And when I say race, I want to point out that that includes not only race, it includes color, national origin, or being a part of an ethnic group that may have certain characteristics or shared ancestry. So without having to repeat all of that every time, I'll just refer to race, but please understand it's bigger than that. It also includes disability under Section 504 in Title II, and then sex discrimination with a particular focus on harassment pursuant to Title IX. It's important to point out that all of these statutes have implementing regulations, which is really where we derive our procedures and policies related to enforcing these statutes. Next slide, please. So next slide, please, talk about the background of harassment and why harassment is a very big concern in our agencies and elsewhere. Harassment based on race, sex, and/or disability is a form of discrimination that violates a person's civil right. It can deny students equal educational opportunities because the harassment can result in anxiety. It can make students afraid, very legitimately afraid, to attend school, to attend a certain class, a program, to ride the bus. And so students are afforded through the statutes that we enforce the right to have equal educational opportunities, the same as any other student that's attending that particular school. It also can create a hostile environment. And I know we talked about a hostile environment previously, and in the same vein, we also look at hostile environment. Oftentimes, when I talk about a hostile environment, it is things going on that may, in isolation, seem small, but the environment it raises becomes very oppressive to students, whether it be students of color, whether it be females or male students or students with a disability. So it's one of the critical things that we like to look at when we conduct our investigations. We also look at bullying and whether bullying itself rises to the level of being harassment. And we will talk about in the next couple slides what that entails. So if we could go to the next slide, please. Harassment versus bullying is really important to discuss when we talk about whether there is discriminatory harassment going on. The specific label used, whether it be bullying, hazing, teasing, does not determine whether discriminatory harassment has or hasn't occurred under the civil rights laws that we enforce. Really, what we do is look at the nature of the conduct itself and assess it for civil rights applications. So we are not so concerned about the label on it, but the actual conduct itself. Some student misconduct that falls under the school's anti-bullying policy can also trigger responsibility under one or more of the civil rights statutes enforced by OCR. Much of the harassment that we see involves peer-to-peer harassment, so students harassing other students. For it to rise to the level of a hostile environment, we look at whether it is sufficiently serious, persistent, pervasive, and sorry to take a little Pause there. Whereas bullying can be taunts, and it may not be sufficiently serious under the laws OCR enforces to deny student participation. So if we can go to the next slide. I'd like to talk about what is harassment specifically. And if we could go to the next slide, please. Harassing conduct, as Marcella explained earlier, is typically unwelcome conduct. General examples include verbal abuse, graphic or written statements, physical assault, and other conduct that may be threatening, harmful, or humiliating. I would like to point out that when we talk about verbal abuse, we have to be sure to remember that this can include racial slurs, racial epithets, other types of slurs that can be used, or just abusive language overall. One of the things that we will look at is about the severe and pervasiveness of any type of harassing conduct. And so when we look at verbal abuse, if somebody is using a racial slur, that may be more severe than if it's more taunting. We also look at the age of the particular student involved when we look at these things, because a younger student may be more impacted with fewer taunts or comments than perhaps an older student. It also matters whether these are from peers, as we said, other students, or actually employees of a particular school district, college, or university. Can we go to the next slide, please? So definitions. In all cases, it's important to remember that the conduct must be based on a protected class, whether that be race with all the other members of this particular category, sex, or disability, and that it interferes with the student's equal access to education. When we talk about what is harassment based on race or disability, we look at conduct that is sufficiently severe, pervasive, or persistent so as to interfere with or limit a student's ability to participate in or benefit from services, activities, or opportunities offered by the school. When we unpack this, as I indicated previously, something that's sufficiently severe really varies depending on the student. So we have an objective component, but we most definitely have a subjective component. So a student with a disability, depending on their level of functioning, certain things that could be said or images they could be shown may be more severe because of the student than if, again, showed to an older student, an adult student. So we definitely take that into consideration. Pervasiveness is very much about how pervasive is this, either throughout the school itself or based on within a particular group of students, whether it's in a classroom or it's in a program. We also look at that, and persistent, how often it happens, how the numerosity, let's say. And we want you to remember that when we talk about a benefit or service from a school district, that it's important to remember that that doesn't mean the educational community as a whole. It could be participation on a extracurricular athletic activity or in an extracurricular group. It could be lunch is a benefit that a school provides or a service. It could be in transportation to and from the school. So you don't have to look at the school and what's happening during the bulk of the day to mean that it's harassment that's limited a student from benefiting from a service or opportunity offered by the school. Now, when we talk about sexual harassment, we talk about whether an employee of the recipient, so that's usually the school district, university, or college, is conditioning the provision of an aid, benefit, or service on the hope that they will receive sexual favors that are unwelcome or engage in some kind of unwelcome sexual conduct. We call that quid pro quo, which we literally means trading one for the other. If you scratch my back, I'll scratch your back. There's also the idea of hostile environment, which we've talked about, which is unwelcome conduct determined by a reasonable person to be so severe, pervasive, and objectively offensive that it effectively denies a person equal access to a recipient's educational programs or activity. We also look at sexual assault, dating violence, domestic violence, or stalking based on sex as defined under the Clery Act and the Violence Against Women Act. Next slide, please. Now, a hostile environment based on age, disability, or sex, most common comes in the form of peer harassment. That means that a student is harassing another student or a group of students is harassing another student. But what we really look at is how the district addressed that harassment. The recipient in this case is a public school district, college, or university. And we always look at what the school district did and if it fulfilled the obligations it's required to under the laws that we enforce. To be harassment, again, it must affect the student's ability to participate or benefit from the program or activities offered at the school. The determination of a hostile environment is always based on a totality of the circumstances. So we don't limit it to one kid or one particular act. We want to look at the totality of everything that occurred as a whole, as we considered whether hostile environment has occurred. We considered both subjective, how did the complainant actually perceive the conduct, and objective. That would mean how would a reasonable person perceive the conduct? So we want to look at both perspectives. Also, conduct by an employee that gives rise to a hostile environment claim could also give rise to a claim of different treatment, which would be discrimination based on protected characteristics. So if an employee, like a teacher or professor or a staff member, is part of this hostile environment, it also creates a claim. And we talk about different treatment, but what we look at is white students treated better by this employee than, say, students of colors. And that in of itself, it's its own category of discrimination. Next slide, please. So quickly, let's talk about notice requirements. Next slide, please. When a school district is considered on notice of harassment, when we talk about race or disability-based harassment, when we want to know when the school knew about the harassment or with the exercise of reasonable care should have known of the harassing conduct. That is called actual notice or constructive notice. Actual notice is when a teacher or employee observes conduct that is sexually or that is harassing and rises to the level of a hostile environment, or when reasonable people should have known. So say a educational aide had overseen some back and forth, and that person may not be exactly sure what's going on, but they perceive it to be some form of harassment. Sex harassment is under our new regulations that came out in 2020. It requires actual knowledge of the sexual harassment or the allegations of sexual harassment. What that means that any person who believes they have been the victim of sexual harassment or the parent of the victim of sexual harassment needs to report it to the school district. That is what creates actual knowledge. Reporting it to a teacher, if we're in a K through 12 setting, or other staff person, can be all the notice that is required. But when we get into college and post-secondary institutions, the notice is limited and has to go to a Title IX coordinator. Next slide, please. Focusing on Title IX and notice, again, in elementary, secondary schools, telling any school employee puts the district on notice. At the post-secondary level, again, it's Title IX coordinator. Schools, even elementary, secondary schools, are all required to have Title IX coordinators in place. And that information, whether it's a school, college, university, has to be readily available to community members, parents, and students. Next slide, please. Now we're going to talk about responding to harassment. Next slide, please. How must the school respond to a notice of harassment? When dealing with race-based or disability-based harassment, the school district must take immediate and appropriate action to investigate or otherwise determine what occurred. This is a really important point. Once you put a school on notice that harassment is occurring, or you believe harassment to be occurring, the school must act. It cannot sit on its laurels, if you will, or not investigate these allegations. It doesn't matter if at the end of the investigation, the school determines that this conduct was not harassment. But when it first comes to their knowledge, they need to conduct an investigation. And that in itself sometimes is very problematic. If a parent goes to a school district and says, my child's being bullied and called names, they don't necessarily have to say it is actual harassment to trigger the school's obligation to conduct an investigation. So we're not looking for certain magic words to be said or very specific words to be said. We're looking for parents and students to notify school district, colleges, or universities. And in response to that notice, the school, college, or university has to look into the allegations through an investigation. The inquiry must be prompt or quick. It must be thorough and impartial. So we look at prompt and equitable when we assess whether a school responded to an allegation of sexual or racial or disability harassment. If the investigation by the school reveals that discriminatory harassment has occurred, the school district or college or university must take prompt and effective steps to eliminate any hostile environment and its effects and prevent harassment from occurring or reoccurring. So an interesting example is if a student of color is being harassed, and the harassment spreads, let's say, or it goes from some name calling to racial slurs being used to now graffiti or images being drawn in the school. That is slowly but surely creating a hostile environment. And the school can't just discipline, let's say, the alleged harasser in this particular case or alleged harassers. They have to look at the totality of the circumstances to also address this hostile environment. That could include providing the student or multiple students, in this case of color, counseling, moving the alleged harasser from classes or being in the same area as his or her victims. So it's bigger than just disciplining the student who engaged in the harassment. The school has to address all of it to make sure that the students who were the victims in this case can feel safe, either attending school, returning to school if they felt they couldn't attend, whether it be on the bus, whether it be in the hallways, whether it be in an extracurricular activity. When we talk about sexual harassment, school districts and colleges and universities must respond promptly in a manner that is not deliberately indifferent or in a manner that is clearly unreasonable in light of the circumstances. So we look for there to be a response that is not specifically indifferent to the student or whoever the victim was, or makes no sense, is clearly unreasonable. If we involve the Title IX coordinator, which I believe should involve in any investigation of sexual harassment, The Title IX coordinator must provide information to the complainant. It could be the parent or the student, depending on the age of the student. And it doesn't matter whether a formal complaint is filed or not, but the Title IX coordinator has to advise the victim of the availability of supportive measures, the right to file a formal complaint, and how to file a formal complaint. Next slide, please. There's specific things I want to mention regarding disability harassment and race harassment. The school should always take steps in its response reasonably calculated to end the harassment, eliminate any hostile environment, prevent harassment from recurring, remedying the effects of the harassment, and preventing retaliations against persons harassed or the complainant. So prevention is very important of preventing harassment from continuing to occur. Next slide, please. Real quick, when we talk about students with disabilities who are harassed, a lot of times that can involve peers calling students with disability stupid, dumb, retarded, lots of things. And that is very much unwelcome comments being made to a student with a disability. But if the student with the disability is on a 504 plan or an IEP, there is this other road over here that we need to consider, which is whether the student during this harassment is receiving a free appropriate public education, or a FAPE, which it's called. So if a student with a disability is being harassed, again, on any basis, not just necessarily their disability, the school district has to go a step further and ensure that the student still receives a FAPE. And they have to make sure that if FAPE was deprived in the past, that is remedied as well through some kind of compensatory services or compensatory education. Also, if students have changed because of the harassment, the school would have to offer additional services or perhaps different services. Just very quickly, a student with a disability who suffers from anxiety, who is harassed, and it may not be related to their disability or quite frankly, related to their race or their sex. It could just be taunting or teasing, but nonetheless, we discovered that the reasons the harassers harassed the student was because they wanted to see, in this case, the student's response. Some students with disabilities can be quick to respond in a way that is very physical or perhaps more aggressive than needed. And we have seen several times where that was the intended outcome of this teasing and taunting, was the response that gets the student in trouble, the student that was being harassed and troubled. So that's one way of depriving a student of a FAPE if they are constantly being disciplined and investigated for their response to what is harassment, that is harassment from another student trying to invoke that response. Also, students, again, I'll use anxiety, may find that they begin to close down, even if the harassing comments don't rise to the level of unlawful harassment under the laws we enforce. So again, it could be taunting or teasing, but as a result, the student doesn't want to come to school, they don't want to participate in class, they don't want to go to a particular class. That too is potentially a deprivation of FAPE, and a school has to look at that as a whole. Next slide, please. Talking about Title IX responses and requirements, that means sexual harassment. Schools with actual knowledge of harassment must respond promptly and in a manner that is not deliberately indifferent. Title IX coordinators must, again, promptly contact the complainant or complaining student or parent to discuss the availability of supportive measures. Supportive measures is what can a school do right away, pending any investigation it's going to do to help remedy the problem or support the student. We think about this in colleges and universities where there's been a sexual harassment or perhaps a sexual assault in housing to move students that were alleged to have done the harassment into different dorms. We also see it in classes at the elementary, secondary level, and the student who is the alleged harasser is moved. We don't promote students who were the victim of being moved anywhere else, unless that's the preferred supportive measure that they want to put in place. Next slide, please. Remedy harassment. Next slide, please. So here are some possible remedies for harassment. Limiting interaction between the harasser and the harassed student. Providing opportunity for the harassed student, an additional opportunity to obtain a benefit that was denied. So again, a lot of times when harassment is ongoing, we see students stop attending school, and they may have had very real life repercussions from that, such as they missed a test, they missed a class, their grades for certain reasons began to fall. And we look for school districts to provide opportunities to that particular student to remedy that. Provide students services to students who were denied benefits. That could be academic support services such as tutoring, extra time on tests, whatever is needed to kind of allow that student to get back to where they were prior to the harassment. We also look for districts to provide, or schools to provide, counseling to the student that was harassed, but also to the harasser, the alleged harasser, because perhaps, you know, figuring out where the harasser background and whether they have social emotional needs or that aren't being met or could benefit from support can help stop harassment. And then we always want the school or the college, university to implement a monitoring plan so that they are watching for harassment, whether it be for the individual student who was the victim of harassment or just harassment as a whole throughout the student population. Next slide, please. So when we talk about how OCR can help, I initially mentioned about filing complaints. Next slide, please. But you can also request technical assistance in a particular school or an educational setting, and we can provide it, which can be very helpful way to provide training to staff, educators, administrators. Next slide, please. We also have a large amount of guidance on our guidance portal, which can be reached at these websites. But if you go through the www.ed.gov site, you can search for various policy documents that we have. Next slide, please. Next slide, please. Next slide, please. Next slide, please. If you want to contact our office to ask any questions, you are free to just give us a call and we will be happy to answer any question we can. We can't give you legal advice, but we can point you in the direction on how to potentially file a complaint or what we see as perhaps being a problem. So again, thank you so much for your time and attention, and I will turn it back over to Tony.
All right, thank you, Ms. Baldwin, for that informative presentation. I'm sure we'll have, I want to remind everyone that we will be having a Q&A question and answer session following our final presenter. But it has helped us to learn not only about federal obligations for schools but also possible remedies. So we thank you. So now we have taken a close look at how both state and federal laws mandate schools to provide environments that are free from hate and discrimination. It's only right that we explore practical ways to achieve such environments. I'm pleased to welcome our next presenter, Dr. Jess Weiler, who is an associate professor in the Educational Leadership Program at Western Carolina University. She earned her PhD in Educational Leadership and Policy Analysis from the University of Wisconsin-Madison. Under her direction, the Educational Leadership Program at WCU earned membership in the University Council for Education Administration, WSU's Academic Program of the Year for 2021, and the 2021 Program of the Year Award for the Carnegie Project for the Education Doctorate. In addition, Dr. Weiler and her colleagues have been awarded over $6.1 million in grant funds from the North Carolina Principal Fellows Program to improve principal preparation in ways that lead to more just outcomes, especially for marginalized students. Dr. Weiler served as speech language pathologist, special education teacher, assistant principal, professional development provider, and leadership coach in PK through 12 public schools for over 15 years. Before moving into academia, she continues to coach practicing school leaders, building their capacity to develop, grow, and sustain collaborative learning cultures in systems that center equity and justice. Dr. Weiler is actively involved in education policy in the state of North Carolina and is committed to achieving greater accountability for equity-driven school leadership. Dr. Weiler's research explores leadership for equitable and socially just schools. One of her recent articles, co-authored with the distinguished scholar Dr. Kofi Lamoti, is titled Defining Rigor in Justice-Oriented Ed Programs, Preparing Leaders to Disrupt and Transform Schools. Her resource interests include leadership preparation for socially just PK through 12 schools, district-wide systems-level equity-oriented change, and building organizational district-wide capacity for socially just schools. Dr. Weiler strives to prepare educational leaders committed to research-supported, community-engaged, caring, and socially just school systems. Dr. Weiler, floor is now yours.
Wow, thank you so much. I'm assuming that you all can hear me. Let me know if you can't. Thank you for the introduction, and thank you for inviting me to be a part of this critical conversation on creating schools that are safe and free from hate. This is especially poignant for me as a mother of public school children, a scholar oriented toward equity in schools, and a professor preparing school leaders in the state of North Carolina, where 10 days ago, House Bill 187, the so-called Equality in Education Bill, was sent to committee. Quoting the Public School Forum of North Carolina, this bill would limit educators' ability to discuss the reality of racism in the United States, would restrict students' engagement with history and current events, and would hinder districts' effort to understand and tackle the root cause of inequities in our schools. A prior bill introduced in February but vetoed by our governor, the so-called Parent Bill of Rights, would have threatened the trust between teachers and students and made schools unsafe spaces for LGBTQ and questioning children. Fortunately, Michigan is making better choices than North Carolina right now. I was asked to talk practice. How do we proactively create safe and inclusive schools that are free from hate? No surprise, it requires a system-wide effort. Here I am doing a Zoom, which I do a million times, and I can't get my slide changed. There we go. All right. So let's start with some of the titles that are at the center of this discussion. Legal language often serves as a barrier to practice, right? So as I often say to my students, let's demystify the language a little bit. So this is simple. We heard the complexities before me, but no person shall be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program. Title IX prohibits discrimination, exclusion, denial, limitation, or separation. What this amounts to is access. This really is an issue of access. Let's talk a little bit about that. Here are just a few examples. Segregating students of different races into separate schools or classrooms, denying them access to high-quality educational opportunities. A school district fails to provide English language learners with adequate language support services or intentionally places them in lower level classes.
disproportionately suspending and expelling African American students, disproportionate placement of African American students in remediation or special education, operating a school to prison pipeline that funnels Black students into the criminal justice system for minor infractions, or denying a transgender student access to the locker room or bathroom that align with their gender identity. These practices harm children. The educators I teach often struggle with this statement, and rightfully so, because they are well-intentioned educators who would never want to harm their students. I suggest, however, that school structures often provide the conditions for injustice to thrive. So, why are we denying access? Let's focus on the denial of access to high-quality teaching and learning. Most schools and school systems were designed around a socially constructed norm that meets the needs of white, non-disabled, economically advantaged, cisgendered, English-speaking students, while actively marginalizing Black, Latinx, Indigenous, disabled, LGBTQ+, linguistically diverse students, as well as students experiencing poverty. Schools continue to seek an assimilation to the norm, to the way schools presently are. Educators often see the source of student struggle as a deficit within the student, their family, or their community, not as a deficit that exists within the school system, what Paul Gorski calls a structural deficit. And I would add a fourth bullet here. One of the reasons that we often deny access is because we're unaware of it. We're unaware of the ways in which we deny access. In fact, we often deny access when we are intending to create access. For example, we continue to pull students out of the classroom for remediation or special education because we assume that we can better educate students who struggle in separate settings, and that these separate settings serve as a space where we can provide better access to the curriculum. Decades of research have shown that this assumption is false, and that students do better when they remain in the classroom with their peers. Thinking back on our third bullet, educators tend to see the source of student struggle as a deficit within the student, their family, or community. This figure shows deficit view denies access and creates harm. Starting our gaze at the red arrow with students experiencing poverty, or we could just as easily insert other marginalized groups here. When educators, and at this point, most white women, but not always, apply a deficit view that's often accompanied by a stereotypical view of students and families, low expectations result. Low expectations often result in the removal of students from the classroom into a remedial program, which perpetuates student failure and diminishes their chances of graduation and the financial rewards and the quality of life outcomes that come with it. So let's take a look at this cycle. In this cycle, we see a different possibility. By shifting from a deficit-based lens to an assets-based lens, recognizing what students, families, communities can do, what skills, gifts, and knowledge they do have. Instead of blaming students and families, we consider the structural and systemic inequities that are present within our schools, the ones that educators have control over. In this cycle, we uphold an assets view to better engage with and learn from families. We advance our own identity development. We hold high expectations for students. We ensure identity responsive and rigorous learning, all of which creates the cycle. So why are we denying access? Let's do a couple more of these. We're just beginning to understand what this work looks like. And the resistance to the work to change our systems is strong and persistent. Some systems do not have the political will or the support to do the work. So what are my recommendations? And this isn't just from me. This is from the scholarship, of course. School systems must be proactive, not just reactive toward discrimination and denial of access. And in doing so, school systems must recognize and take responsibility for the ways in which their systems, their policies, their structures, their practices foster discrimination and deny access. Working side by side with their communities. Can't say this enough. We're learning in all the scholarship that a lot of the work we do to reform schools, we're not doing it with community members. We have to do it with community members. We must commit to and enact system-wide changes to create the conditions that discourage discrimination and the denial of access. So what is system-wide change? You know, I'm going to go right by this slide because I think we're running a little bit out of time, but we'll come back to it if we need to. So I'm going to move my script to go there. This is an example, what you're seeing here, of a framework for system-wide equity. It is called Integrated Comprehensive Systems for Equity and was designed by Drs. Colleen Capper and Elise Fertura. They've been implementing this work for over 2 decades in states across the US. I do not present it as a solution, but as an example to illustrate both the parts and the complexity of systemic work. This framework engages the research on effective teaching and learning, as well as scholarship from Black, Latinx, Indian American, feminist, disability, and queer scholars. It attempts to build organizational capacity, system-wide capacity, through teaming and in-depth learning models. In this work, all the members of the school system are involved. The first thing is to learn the history of educational marginalization, how we got to where we are. The second is to shift from a deficit to an asset-based view in not only our thinking, but our language and our practices. We then engage identity development, coming to understand the role of privilege, the importance of understanding our positionality, our relationship to those in which we work and serve, applying the research, uprooting our assumptions about what works in education, and leveraging the research, decades of research. Developing equity non-negotiables, equity principles that guide our decision-making. Conducting equity audits. This one is so important to reduce disproportionality and set goals for increased access to high-quality teaching and learning in spaces of belonging. I recommend equity audits because oftentimes schools are not aware of the ways in which they are inequitable, and that can often serve as a starting point. The next thing is to realign staff and students to build strong teams and to utilize those teams to co-plan together to serve students. It's also a learning team, a continuous learning team. Then they design identity relevant teaching and learning, providing instruction that is identity relevant across all identities and their intersections. Aligning human resource systems, example, hiring teachers of color, creating job postings that reflect the district's integrated classroom approach, leveraging funding with a focus on reallocation, and cross-checking policy. What policies need to be changed to represent the equity principles? Again, it's a lot to digest in today's time period, but it's critical to understand the importance of getting the entire system on board. In closing, I offer some inspiring words from Nelson Mandela. It is not beyond our power to create a world in which all children have access to a good education. Thank you for your kind ear.
Wow, a lot of great information shared today. Thank you. Thank you very much for your presentation, Dr. Weiler. Your work is inspiring, and I'm sure that we should have pretty good questions. So now I'm going to ask our panelists if you will turn for our panelists, if you'll turn your cameras back on, and we'll begin taking any questions. Not sure, do we currently have any questions? I don't see any in the chat. I don't see in chat, but I do have a couple of questions if you don't mind. If you don't mind, I do have, like I said, I do have a question here. Marcelina, for students who may have experienced discrimination at school, can you please walk us through what their involvement with the Michigan Department of Social Education might look like, what their involvement might look like should they choose to file a complaint?
This is Marcelina speaking. Thank you for that question. Yes, so if and when someone chooses to file allegations of unlawful discrimination with our department, if it is a student, a minor student, we would have their parent who has guardianship or is legally allowed to file a complaint on their behalf be the claimant on that complaint. And what you do is you can contact our department either by telephone, email, or even a web complaint form submission. You will be contacted by an intake staff person who will walk through and do an interview with the parent and guardian of the student to get all of the information necessary to take a certified complaint. And once that is done, it is passed on to an investigator at our department in which you will be working with throughout the investigation. At that time, when we take a complaint, we allow whoever the respondent is, right, in this case, the educational institution, to answer that complaint. And the investigator works also with you in getting a rebuttal or response to how the school responded to these incidents and allegations. I will say it's very important when you're filing a complaint and interacting with the school officials when we're talking about complaints to make sure that the communications with that school is documented, right? What happened? When did it happen? How often did it happen? And all of those things so that you have a timeline in order to share and make the investigation smoother as far as the allegations and in order to get a response from the school district or educational institution in that matter. Should I go on to if then we make a determination? I'm sorry, Tony. Yes, so then after the investigation, the department will make a finding of either sufficient evidence or insufficient evidence to proceed with some type of charge. However, throughout the investigation, we do look to see if there are any remedies, any type of settlement, and that can look, depending on the situation, that can look very different for individuals in that manner.
All right, thank you. We have a question from one of our participants. Is there a way to insulate schools? And this is a general question for everyone. Is there a way to insulate schools from hate and bias within the larger community? You know, like in essence, you know, what if the parents, you know, are worse than the students, you know, in terms of their willingness to engage in hateful rhetoric or their willingness to engage in those types of hate and bias activity.
I'll do the best I can, or I'll go first. When you talk about insulating a school district, it can be really hard because it's a public institution. If we're talking the K through 12, there's some level of free speech rights that are afforded to, quite frankly, all members, community, educators, students. I just was dealing with a situation where one of our complainants, which was a parent, was very upset about a Facebook group of parents that were discussing a situation that she felt reflected poorly on her child. And school districts don't really have control over that. I mean, that has to come really from the community level. I think it's also pointing out that when we're trying to insulate school districts, sometimes it's the community that can make it difficult versus the community necessarily making it better. I mean, boards of education oftentimes pass policies that will discriminate against LGBTQ plus students or other types of students, and they of course reflect the community, or believe they reflect the community, and it may be something educators really can't get behind, but their hands are tied. So just my thoughts.
Yes, and also I think that schools, most schools are in communities. They're actually, they are in communities, and schools are members of the community, and they're integral parts of the community. And I think that approach by embracing their role in the community, and I think that approach possibly hosting things that could help bring some kind of cultural understanding, understanding of different cultures, and also reiterating in terms of school policy and actually being accountable for those school policies. I think there's a lot of ways, but unfortunately, yes, it would probably be difficult to truly insulate a school from that. I think that you can do the best that you can, but it's probably difficult to truly insulate a school. So I have another question on Dr. Weiler. In your presentation, you talked about designing identity relevant teaching and learning for all learners. Can you talk about the dangers, what we've seen happening across the United States with content relating to like social identities of specific groups,
Right.
like banned in certain districts and that type of thing?
Yeah, we're feeling it's real here for sure. Great question. Just when we're starting to understand how to make schools safer and more inclusive for students, we're being told not to. So we have our work cut out for us. Banning content that's relating to the social identities of specific groups can have serious consequences for free speech, critical thinking, understanding the experiences of others, and it makes schools unsafe for marginalized students. When certain topics are not discussed or are avoided, students may not understand the experiences of others or the ways in which they may have themselves contributed to inequality or injustice. It also sends a message that the experiences and identities of students who identify differently than the socially constructed norm are not valued or important. It can contribute to a climate of fear and intolerance, and it can make it more difficult for these groups to feel safe and included in their schools and community. It's a problem.
No, we have a couple of questions. I have one now. And I think Dr. Weiler, this probably is also along those lines. We have issues involving one of our attendees says we have some serious issues involving LGBTQIA students and then feeling safe in school. What can be done?
Yeah, so I teach both master students, teachers who want to become school principals, and also EDD students, folks who want to work in district office, and they're asking this question all of the time. And it's easier for some than others, those that are working in regions that are supportive of the LGBTQ community. And then there are others where it can't be brought up for fear that they might lose their job. So there's really not one answer, except for most of the time we talk about how important the communication piece is and how we are all in this to help and work with children. And I know that when I was a school administrator, if I had to discuss things with other parents who maybe or other community members that were pushing back, we had to center the child. We had to remind people about the child. And we could usually any conversation where there was resistance to students who identified as LGBTQ, agreement that all children deserve to feel safe, to feel loved, to feel as if they belong. And so the communication piece is very important. And we also have to provide spaces for them, not only in the classroom, but in clubs. And we also have to make sure that there are places within the school that they can go if they don't feel safe. And there's some research that came out from Dr. Molly Blackburn on this, with some statistics about, and from GLSEN, about how safe LGBTQ students feel or don't feel. And oftentimes the number is something like they felt as if one, maybe two teachers in their school served as places where they could go and feel safe. And so we have to make sure that we have not only spaces, but faculty and teachers and people who can help students who need that.
If I may also add to that as well, now in the state of Michigan, I think that communication piece that was just talked about is very important, right? The first steps of communicating with the school leadership and staff. But if that does not happen, as I mentioned, in the state of Michigan, we have state civil rights laws that I mentioned earlier in the presentation, where allegations of unlawful discrimination based on your sexual orientation, based on your gender identity or gender expression are now prohibited in this state. And there are those safeguards as well. And so if you as a parent, as a student, are needing resources or feel that it is time to file a complaint with our department, we will do those investigations, in addition to potentially being able to provide support through our community engagement division as well. And those they're separate, but they also go hand in hand as it pertains to our department to ensure that LGBTQ+ students are feeling safe and have equal and full access to their education.
All right, yes, thank you. I think we have time for a couple more, maybe one or two more questions. How do you see, for our panelists or Dr. Weiler, how do you see restorative practices addressing these injustices and inequities?
Restorative practices are so very important. In many cases, we're often implementing them in response to having the ways in which we handle discipline are problematic. And restorative justice is so much about making sure that when there's a discipline infraction, there's often a breakdown in the relationship, say between the teacher and the student. And so we need to make sure that when there is a relationship break, that is restored. Because when there is a strong relationship between a teacher and a student, for example, in a classroom, then we're creating a safe space and we're creating a place where learning can happen, right? But oftentimes without the restorative piece that happens when we think about the different ways of doing restorative practices, when we don't bring that in and we've had a discipline infraction, that oftentimes that begins, depending on what that is, a spiral, downward spiral for a student, and can be very hard to reintegrate into a community, right? And it's also important because we need to give voice to students. Restorative practices often do that, whereas our traditional sort of look at our code of conduct and apply a response does not do that. And so there's all kinds of promise coming out of those practices.
If I may jump in. I very much support restorative justice. The times that we see, at least in my practice, that it can be problematic is when a school wants a student who's a victim of harassment to restore through the restorative justice program or module they have at their individual schools with their harasser. And that can be very problematic. I think it can be very injurious to the student. And a lot of thought has to be given how restorative justice is used. There are some, and of course, you know, this is looking at it from a different perspective with probably a much smaller universe of students that we're talking about, but it doesn't always, in a harassment perspective, you know, it's not necessarily a workable relationship. And when we do our investigations, when there has been perhaps a delay in trying to deal with the harassment at issue because of a restorative justice process, which kind of slows things down and allows actually additional harassment to occur if it's been ongoing, and we have a real problem with that. It's not something that we can say, oh yeah, put a pin in everything while you go through this process. So I think it works and it's very positive, but I think there are a few situations where it is not the best process to use.
So we'll have another question. Maybe we got time for maybe one or two more questions. So I want to make sure we get to our, to our participants, our attendees' questions. Can the panelists speak to how parents or community members can know when to file a complaint versus mediation or some other response? Because, sometimes people dig in their heels rather than address the problems.
This is Marcelina speaking. So I would say, going back to the communication piece, if incidents are occurring that are affecting your student, your child in the educational institution that they're in, that communication, the initial communication with the school to put them on notice of what is happening. And if you're not feeling like anything is being remedied or that the school isn't listening, then it may be time to file a complaint. I will say though, with our department, when you file a complaint, we are always looking for some type of resolution, whether it's mediation to address the issue during the investigation or some type of settlement. So that's never off of the table as it pertains to complaints that are filed with our department. It doesn't mean that it can't be remedied or something can't be worked out with the school to address the situation that your student or yourself are facing.
This is Chandra. As it comes to a situation in a school, I think it's always a good idea to put a school on notice that there's a problem, to see if they'll remedy the situation. But you don't wait too long for that. It helps ensure that, at least from my perspective, if I'm going to do an investigation, that we can establish the necessary notice provisions or actual knowledge provisions. If you file a complaint with OCR, we have a fairly short statute of limitation period of only 180 days. So I never want to encourage people who may want to go the route of filing with OCR to wait too long because of that very short statute of limitations. But one of the things we offer and we find very successful is an early mediation, whereas when you fill out your actual complaint form, we ask if you are interested in engaging in early mediation. And if you are, you just check that box and we just start out from the get-go trying to get mediation scheduled. It's always voluntary with our office to engage in mediation. It's not required. There's no exhaustion requirement, but we find it very effective because if you're dealing with an ongoing issue, it could take, and that's the other thing, we can take a very long time to investigate a complaint just because of different competing interests and other complaints. That's very long in the life of a student who feels they're being victimized. And so mediation can oftentimes be a better, quicker way to go to get the results that your student needs to be able to have a successful school experience or to address issues that are pending.
All right, thank you. I'm going to squeeze one more question in here. And I guess this is for For our panelists, could a school system's failure to provide culturally relevant teaching for all be framed as a civil rights issue?
That's a really great question. That's a really great question. I personally think that when we don't have culturally relevant or culturally sustaining practices in classrooms, in the curriculum and in the pedagogy, that we are denying access of teaching and learning, especially to those in which we've ignored, right? Those in which cultures we've ignored. I don't know whether that has a legal case, but I would say that's, our panelists can certainly talk about that. I've had folks ask me those questions when we're trying to talk about the need for systemic work. Can we show how there's a denial of access to when you pull somebody out and you put them in remediation, or you put them in special ed, or if even you do ability grouping, or if you pull them out on the side in the classroom, that type of segregated learning does deny access to high quality teaching and learning. We see that in the research. Does it rise to a legal complaint? I'll leave that to the other panelists.
This is Chandra. Sorry to keep, bumping in, but we, at least in my office at OCR, are looking at this very legally. And while I think from a personal level, that is a denial of civil rights and an important piece of any educational program, from a legal perspective, it's very difficult to say that in and of itself is, because we look at basically the laws and how we enforce them, and is not providing a educational program related to other aspects, other cultures, taught to all students. Is that a problem from a civil rights legal perspective? I mean, I don't want to say no, it's so fact specific, but I would lean towards the no, because there's no requirement legally that be done. Once that requirement is made, let's say, then, we have the, if you will, the teeth then to do something about the fact that it's not occurring. But it's not required under the statutes, at least that we enforce, or the regulations we enforce.
This is Marcelina speaking. So just even to take that a little bit further, and again, yes, being fact specific, on its face, I agree with my colleagues. However, when we're looking at even some of the curriculum that is taught, one of the issues that we've seen at the department is how the curriculum is taught and the impact that it has on certain students, students of color. For example, in the past, we've had where schools teach the curriculum on slavery. Now, it's not the issue of teaching slavery, but it's the activities that are used to demonstrate the impact of slavery on today's children in the schools. And so I would agree with my colleagues that no, maybe not on its face. However, there may be facts specific to the teachings, how things are taught. I'll leave it there. Yeah.
Wow, thank you. This has been, been excellent, excellent information. Your expertise, your insights have been invaluable. I want to thank all of our registered participants, who have viewed us via the live stream. Also, I would like to invite everyone to come back to our next campaign forum, which is scheduled for Thursday, April 27th, 2023, from 1:30 p.m. in the afternoon to 3:30 p.m. in the afternoon. So I want to remind everyone that our Thursday, April 27th, our next forum will be from 1:30 p.m. to 3:30 p.m. This next forum will focus on mitigating bias in Michigan housing. You can learn more about the My Response to Hate campaign by visiting the Michigan Department of Civil Rights website at michigan.gov/MDCR, where you can also explore ways to be involved. Please be sure to check out the pledge that's available for download and distribution. And remember that eliminating hate and bias in our state is all of our responsibilities. Thank you very much for participating this evening. I thank our, really appreciate and thank all of our panelists. Thank you for joining us. We wish you all a safe and restful evening. And everyone, thank you very much for participating. Have a good evening.